So happy to have attorney Jessica Fisher-Greene, who is a certified elder law attorney, join us today to present, and from Walters and Galloway, Getting Documents Ordered in a Disorderly Time. I love the name of this presentation because with the pandemic and quarantine and COVID and restrictions, people seem to be at a loss for what should I be doing right now. And this is a good opportunity to take advantage of some time that may be a bit available for you to reassess what documents you need, what are the important things that you need to have on hand, and get updated, or perhaps for the first time get started on some new documents. So without further ado, and my name is Maureen Elliott from Artis Senior Living of West Shore in Lemoyne. Please feel free to reach out to Artis with any questions you might have about memory care and senior living. Without further ado, I'd like to present Jessica.
Hi, thank you, Maureen. And thank you all for joining us. And looks like more people are trickling in as we go along here. If you do have any questions as I am talking, feel free to just unmute yourself, and then you can ask your question. Or also I have the chat window open if you feel more comfortable just typing in your chat question there. I'll try to answer it as we go along. And also, just so you're all aware, we are recording this, so if you want to share it with someone or want to look back on it, we will make that available for everybody. And if we don't have your email address, if you didn't get this through an email, feel free to put your email in the chat window and we'll make sure that we email it directly to you. So thank you all for joining us. As Maureen said, we wanted to put this together since this is such a disorderly time. How do you get things organized? Where do we go from here? And some people don't have anything in place. So this is a great opportunity to discuss what should be done. And even those who already have documents in place, a lot of times, a lot of us are guilty of this. Okay, I got my documents done. I can just shove it in the folder and never look at it again. And you don't actually follow through with what should happen next. So I'm going to talk about all of that today for us. So first off, everyone as a foundation should really have 4 main documents. So it'd be last will and testament, durable financial power of attorney, healthcare power of attorney, and living will. So those are, like I said, the 4 documents that you'd want to start with as a base. And then, depending on what your goals are and what your wishes are, you could always look into trust planning as well. So starting with the last will and testament, this is usually where I would ask how many people have one and raise your hand, but since we can't really see everybody and it's a little bit different, there you go, thanks Lori. Most people have at least heard of this document. This is the document that is looked at after you pass away and only if you have probate property. So what is probate? Probate is a formal process that your will goes through at the County Register of Wills office, wherever county you resided in when you passed away. Your will would be filed there and proven to be valid. And that's how, when it's entered into the probate process, that's what's happening. Once it's been proven to be valid, then the person you've named in the will as your executor will be formally appointed to actually take on that role. Now, we used to always call the person in charge of your will your executor or executrix, so male or female, but now we refer to that person as personal representative. Just kind of more of a unisex term, more PC, if you will, to try to really have it follow and make it more relatable and easier to understand. So with the will, you're going to be naming your personal representative And typically, it's much easier and simpler if you name one person to serve at a time. So if you have one person as your primary personal representative, and then you want to have a backup, so an alternate to the primary, and then you even want to have a second alternate, just in case something would happen to your first two personal representatives that you had put in the document. Now, I often get questions of, can I name more than one person at a time? Can I name all three of my kids at once? Yes, you can do that, but you might not want to do that, because if you would name more than one person to act at a time, then it becomes an issue if they don't get along, or if something, would occur where, say, they're in different parts of the country or they're different parts of the state. They would both have to sign off on every single thing in order to actually have a decision made or move forward on something. So it becomes much easier if you would actually just name one person at a time. So then with that last will and testament, you can also put in who your beneficiaries are. These are the people who are going to inherit your property after you have passed away. You can put in any sort of special provisions that you would like for those individuals. Let's say that you currently have a will with your spouse, and you're leaving everything to your spouse outright, directly to that person. Now, years ago when you created your will, and we call this type of will an I love you will. So I love you to my spouse, so my spouse gets everything. And then when we're both gone, it all goes to our kids or to our other beneficiaries. It's very simple and it goes well and all that's great. But if, say, now your spouse is in some sort of situation, say they're in a nursing home, maybe they're on medical assistance. If they're already receiving a government benefit and your will says you're leaving everything to that person, then that could kick them off of their government benefit involved. So instead of having that happen and then be kicked off their benefit, and then they have to go through the whole process again and all the things that will come with it, what could happen is you could put special language in your will for your spouse so that you are still leaving them money, you are still leaving assets to them, but you've done it in a way that it won't jeopardize their government benefits. Another thing to keep in mind is that you can put additional language in the will to help with a beneficiary who may have some sort of disability, something that, maybe they can't manage money on their own, or maybe they're receiving government benefits not because they're in the nursing home, but because of some other thing that has happened to them or that they were born with. Again, you wouldn't want to leave assets directly to that person because then they could lose their government benefit. So it's very important to make sure that when you are preparing your will and you've put these things together, that you have the right language in there to make sure that not only your wishes will be followed, but you're also protecting those who you are leaving assets to. So you'll notice a trend as I talk about all of these documents. It's great that you may already have them or that you're now looking at getting them done, but once you get them done, the work isn't really done yet. You need to always be looking back over these. Every 3 to 5 years, you should be checking back over these documents and making sure that if your circumstances have changed you're also having your documents reviewed and updated so that you can make sure that you are updating those and they are reflecting your new circumstances. So with that, as I had said earlier, and as we go through the documents, so let's say you have your will done, it was handed to you, okay, now what do you do with it? So there are a number of options. Sometimes people will keep them, the original will is the really important part here. So the original will is what would be needed to file at the courthouse after you pass away. Sometimes people will keep that with their attorney who prepared the will, so that could be a great choice. If they have a fireproof will save, some sort of system in place, you can certainly keep it there and just take copies with you. You could also keep it in, say, if you have your own fireproof safe box at home, that's another option. Or some people will give it to their executor right away and just have the executor keep it safe for them. The one place you do not want to keep this document would be your own safe deposit box. When you keep it in your own safe deposit box, which I know this sounds so silly, what else are you supposed to put in that box, right? That's the box that's supposed to keep your things safe. But the problem is that when you pass away, no one's going to have access to that box. And there would have to be a whole procedure for your executor to be appointed in order to get access to the box. But the executor or personal representative can't be appointed without that original will. So we kind of go full circle here of how do you get the person appointed when the will is actually in the box and they can't get in there with that. So it's a total mess. It's a nightmare. So just avoid that and keep your will, your original will, somewhere else that you know is safe. Another thing that is very helpful, and I'm going to try to share my screen here and go through, let's see here if we can do that. No, okay, let's see, here we go. Okay, we'll try that in 1 second here. Nora, can you help me to make me host? Here we go. So I'm going to show you something that's very helpful for people to fill out when they are actually after they have created their will. This is something that's very, very helpful. And if anyone would like a copy of something like this, or maybe you already have your own, version of something similar to this, but this is what we call our very important papers inventory. So when you have created your will, and we'll go through all the other documents here in a minute, afterwards, you really want to sit down and go through all of your important things. So this first page is all about information that would be needed for your death certificate. I know it's not something that anybody likes to think about, but these are important pieces of information that your personal representative will need to know after you pass away. So kind of going through here, what your occupation was, your parents' names, your place of birth, all these types of things are very important. And then as we get down here talking about medical things, those are really important items for, say, your healthcare power of attorney agent to know about. And we're going to go through that document in a few minutes. But as I scroll down here, it's just really important for your financial power of attorney to know about your expenses. It's all the rage now, especially with what's going on with COVID, to have everything online. You're paying your bills online. You have everything maybe set up on auto pay. A lot of these things are now paperless billing. So the problem is that when something happens to you, your agent has no idea what your expenses are or what's happening because it's all set up online and you never gave them that information. So it's really important to make sure that you are upfront with the people who are going to be following your wishes and handling things for you. Here we have a section about income. Make sure they know all of this information. And then, of course, with asks, listing everything out and really including those online credentials are really, really important so that they have a full picture of how to help you. And then, of course, putting your important representatives at the bottom so they know who to contact. You know, if your will is with your attorney, they need to know who your attorney, they can get that document. And then it just kind of goes on with, you know, important information about what documents you have and who your important people are so they know how to contact them. So I just wanted to share that with you so that you can get an idea of things that you should be doing after you do create your will. So moving on, we're going to talk about financial power of attorney. But before I do that, does anyone have any specific questions about last will and testament before I move on? Okay, great. So I'm going to move on then to the financial power of attorney. Now, this is a document that's very different from the last will and testament because this document is only looked at and effective while you are alive. So like we said with the will is only going to actually come into effect when you've passed away. But the power of attorney is the opposite. The way that those are set up today, we have them set up so that you have a power of attorney that's strictly for finances and legal decisions. So we call that your durable financial power of attorney. And then you'd also have a power of attorney for healthcare. So we call that your healthcare power of attorney. Now, the financial power of attorney is going to be the one that has all of the powers listed in there about how your agent can help you with your finances. So if we had the financial power of attorney document, and say you did create one, but you created it prior to 2015, then you definitely want to have this document reviewed by an attorney to make sure that what you have is still valid and still will be able to accomplish what your goals are. Because there were major changes to the law in 2015 and then again in 2016. And then actually even a couple months ago, there was something additional added with regard to digital assets. So you really need to have these things looked at and make sure that what you have will truly allow you to follow your wishes. Now, I'm not saying that because your document is older than 2015, it's automatically invalid. That's not what I'm saying. They did allow older documents to be grandfathered in, so they are still valid. The problem is that with the new law, they changed the meaning and definitions of a lot of the terms and powers. And they made it very specific that if you want your agent, the person who's going to act for you through this document, if you want that person to have specific powers, they must be listed in the document. If your document does not list those powers, then your agent does not have the power to do those. So some very specific powers, the right to deal with jointly owned accounts. So adding someone as a joint owner with right of survivorship, or removing someone as a joint owner with right of survivorship. Your agent has to have that power listed specifically in your power of attorney, otherwise your agent can't deal with that type of power. Your agent, if you want that person to have the right to change your beneficiaries on, say, a life insurance policy or an annuity, that's another power that must specifically be listed in the document, otherwise your agent cannot do it. Now, a big one that's very important if you are trying to do any sort of tax planning or Medicaid planning, a big one that has to be in there is called unlimited gifts. if you want your agent to be able to do any sort of planning for you and give them very broad power to do that, then you have to have listed in your power of attorney document that your agent has the right to make unlimited gifts. Now, this is something that you need to be very careful about. You definitely want to work with an elder law attorney to make sure that when you have that language in there, you understand the full effect of it, and also your agent will know what to do with that language. That language, a lot of the powers that I've just listed, will give your agent kind of the right tools on their tool belt to help you later if you are unable to help yourself with any sort of planning that you wanted to do. But without that language, your agent's hands will really be tied when they're trying to do tax planning or Medicaid planning for you. It's just something to be, very careful about. Now, with gifting, there's something that a lot of people get confused about, and that is that under the IRS rules, so for tax purposes, you're allowed to give $15,000 per person per year. So that's just something you can give that away, no problem. However, the problem is that Medicaid, the nursing home benefit, they have different rules than the IRS, and the VA has their own set of rules. So everybody, I wish they would get on the same page already, but that's not going to happen anytime soon. So for Medicaid purposes in the nursing home, we're looking at if you have given away more than $500 total in 1 month, then that's an issue. That's not per person. So it's not, I give $500 to my one son here in July, and I give $500 to my other son here in July. No, it's $250 to one and $250 to the other. That's okay. Or I give $500 to one here, where at the end of July, it has to clear my account before the end of July, and then I can write a check for $500 to the other child next month. So just so everyone understands that. And it's not something where at the end of the year we can just call it a day. It does not work that way. Now with Medicaid in the nursing home, they have a 5-year look back. So if you were to make any gifts more than $500 in 1 month, then they have to be outside of that 5-year look back. So if you were in the nursing home, what's going to happen is you would supply your tax returns for 5 years, your bank statements that would all go towards with your medical assistance, all of those, to see if you made any gifts over that $500 mark in that previous 5-year period, 60-month period, however you want to talk about it. So it's just something to be aware of. Now the VA, they have a 3-year look back. So if you've made any gifts prior to your application for aid and attendance, which is a pension benefit, then they are going to look back at your tax returns and your bank statements for 3 years to see if you have given anything away in that 3-year period. So back to the power of attorney, it's just so important, like I said, with the will. As you age and your circumstances change, you really need to have this document looked at. If you're younger and you're in really great health, maybe you don't need to put all those broad powers in there. But as you get older and you start to have some long-term care issues and your goals are changing, you definitely want to add that language in there so that your agent can truly help you later on if something would occur. Now, of course, it would be ideal if everyone would pre-plan, but unfortunately, that's not always the case. So just a little more on financial power of attorney. If you never create this document and you become incapacitated, then your loved ones will have to petition a court in guardianship to be able to help you. So definitely get this document done now while you're able, while you have the ability to understand what you're doing. That's just so very important. Now, same with the will. For the power of attorney agent, please don't appoint more than one person at a time. I know it's tempting. I know it's hard to choose between children, but hey, I always say just blame it on the attorney. Blame it on me. You know, that's gonna say we had to do it. Just throw me right under that bus. That's fine, because otherwise it's going to be just a total nightmare. Even if your kids get along, it's really hard for them to try to get together on every single thing. And banks and other financial institutions are really cracking down on this. Even if your power of attorney document says, you know, Jessica and or Sally as our agents, and it's and or, so I should be able to act without Sally, they still are going to ask for both people to sign because they've been burned. You know, what if I sign something and then Sally comes rushing in the bank and says that never should have happened? It's a huge liability for them, and I really can't blame them for trying to get both people to sign off on things. So like I said, choose one person as our primary agent to make the decisions for you. If that person cannot act, then we have a second one in place. And then let's even have a third one in place if our first two are unable to act. Now, I think what we've all learned during this COVID period is how amazing technology is and how much we can get done through technology now. So I used to get the question, you know, what if my agent is out of town or lives far away? Now I think we've all overcome that, and really your agent can get all these things done for you clear across the country. And that's another thing I want to point out, another change that has occurred. You know, it used to be to probate your will after you pass away. Your executor or your personal representative would have to fly in to the county where you lived to get probate opened. Now, with COVID happening, they have adopted this video conferencing. So we had someone who was in New York the other day, and she got sworn in to be personal representative, executor of her mom's will right from the comfort of her own home. So that's something that's happening now. That's a great change, and I don't see that going away anytime soon. So that's something that you don't need to fear if you don't have a local person. Now we've kind of overcome that. So a question that has come up here, how often should you update your documents? And, you know, it used to be we would say upon the 4 Ds. So if there was a new disease or diagnosis, a decade, 10 years, a divorce, or there was a death, you should update. But now it seems that the laws are changing even more frequently, and our health and our lives, things kind of are going faster. So it also is recommended, instead of every 10 years, to maybe look at them every 3 to 5 years. So moving on from the power of attorney document, again, just such an important document. You definitely want to have that. And if you leave here and you think about you just want to get one document done, I would say definitely the power of attorney would be the most important document for you to get done. So moving on, we're going to talk now about the healthcare power of attorney. So this is different from the financial power of attorney because it allows you, yes, to appoint an agent, just like the financial power of attorney, but this agent is going to focus solely on medical decisions. So in this document, you are waiving HIPAA so that your healthcare agent will be able to see your medical records and help you make an informed decision and really talk to your doctor. So that's kind of the first thing in the document, is always that HIPAA waiver. Then in the document, now this document was updated, the law changed for it in 2018, and then really was enacted last year, that really everyone kind of put it into effect in the beginning of last year. So if yours is older than that, you want to take a look at it. the major changes for this document had to do with organ donation. So if you are an organ donor, you definitely want to have this updated, because all the changes that came about were very helpful. In the old healthcare power of attorney, there was a conflict in the document. And it's something that, it's one of those things, you kind of get used to seeing the document all the time and you don't think, wow, that really never made sense for it to be that way. So they changed it, because on the one page you're saying, I don't want any machines, I don't want anything at all. But then the next page you're saying, well, I do want to have the organ donation process occur. But sometimes for organ donation to happen, after you've passed away, the doctors might need to put your body on a machine to keep the organs running. So now in the new document, it says, I'm okay after I pass away if you do put me on a machine to basically keep my organs good until they can take them out. So there are little things like that that were added that really make a huge difference to them. So with that, the living will is another medical document that is very, very important. The difference between the healthcare power of attorney and the living will is that the healthcare power of attorney is addressing powers that your agent will have at any time. So, I'm in very good health right now, at least I think, I hope, and something happens to me, all of a sudden I drop over. Well, of course, my agent is going to work really hard to get the doctors and get everything done to make sure I'm okay. And they're going to use all their powers in there. If I need surgery, they're going to authorize it. They're going to authorize anything that's needed. And all the powers are listed in the healthcare power of attorney. So authorizing or refusing medical treatment, authorizing or refusing tube feedings, authorizing or withdrawing any sort of care or admission or discharges, really anything you can think of with regard to your medical care, your healthcare agent can do that for you. So whether it's a temporary situation where I'm in an accident, I'm knocked unconscious, my agent will make the decision, I wake up, then I'm good to make my decisions again. Whereas the living will is only looked at if you are permanently unconscious. So you're in that irreversible coma, you're not going to get better, this document will be looked at. Or if you are at the end stage of a terminal medical condition. So we know that you have cancer. You've already given it the good fight. You've gotten all the treatment you can, then now it has spread throughout your entire body. And there's no more treatment that's going to make it go away. That's when we're looking at the living will. So there's a big distinction there. Now, it is very common, though, to combine the healthcare power of attorney and the living will into one document. And that just makes it simpler, so you can hand the whole document to your medical provider, and then they know the two separate parts and which part to be looking at. But in the living will, that's where you're going to say, if I'm at the end stage, I do or I do not want tube feedings. If I'm at the end, I just want to be kept comfortable. I want to make sure that I'm not in pain, and you'll acknowledge that you're okay with being given treatment that will, make sure you're comfortable, but it might have some adverse side effects, like suppressing your breathing or your appetite. It might be habit forming. That's really asking you, are you okay with being given extra morphine to make sure that you're being kept comfortable at the end? And that's just, a lot of personal questions you really have to ask yourself when you are creating these documents. I know they're not fun questions to think about, but we all have to do this now so we don't leave our family members in a lurch later. Now, just like the financial power of attorney, if you never create a healthcare power of attorney or a living will, and a medical decision needs to be created or made for you, then your loved ones, again, they're going to have to petition a court and guardianship to get that power over you and be able to make decisions for you. And if you feel strongly that if you're at the end and you don't want life-prolonging procedures, you really need to create this living will now while you're able, because otherwise, when your guardian is appointed, they're really not going to be able to make that decision for you. It's going to go in front of the court. There are going to be a lot of other people involved. It's not going to be just the one person you would have trusted to make that decision for you. It's just really, really important to make sure that you've looked at this and you're making those decisions. All right, so we had a couple questions come up here. So given COVID, so looking at that, yep. So we had being intubated or not needs to be revisited, and that's a great point with everything that's going on with COVID and the need for ventilators. There is a section on the healthcare power of attorney that we draft that says labeled guidance or goals for my agent. And that's a great opportunity for you to add in any of these concerns. Lori, you hit the nail on the head there. There's a lot of different things popping up, and it's a very scary time. And what you need to do is make sure not only that you have this document created, but that you've also had the conversation with your healthcare agent to make sure they understand where you're coming from when you've made these decisions. So you want to be able to, that conversation is almost even more important than the document. And in the document itself, there's actually a section where you can say, I want my agent to be required to follow these instructions, or I want my agent to use these instructions as guidance, but they can override anything that I have said here. And that's really important to address because, there's a lot of confusion about the ventilators and COVID right now, and especially if someone is older, how does all that play in? So if you give your agent that power to override any of these instructions and talk to them about what that means, then, that could be the difference between getting a ventilator or not, like you said. So, certainly something that needs to be looked at, especially under, the situation that we're in now. So a couple of other things here, like I said, there's some updates with probate now. You can do the video conferences with now getting your documents done. I know a lot of people can't cannot leave that location. So they did pass a law during the emergency so that we are allowed to notarize things remotely. So if a notary is approved by the Commonwealth of Pennsylvania to offer this, then they can go ahead and notarize wills, powers of attorney, healthcare powers of attorney, living wills, all those documents remotely. So what that means is if you're looking at yours at home and you're concerned and you think you need new ones, but you're too scared to leave or you don't want to have contact with someone, we are definitely offering that as an option for people. So feel free to reach out to us because, we understand this is a very difficult time and we want to make it as easy as possible for the people who are going through this and need these documents updated. We're happy to offer those services. So, like I said earlier, at the very least, as a foundation, we want to have last will and testament, durable financial power of attorney, healthcare power of attorney, and living will. But not only do you want to have them, you want to have them updated, and you want to at least talk to whomever you have appointed in those documents to handle your wishes. Maybe you're not comfortable giving them a copy of the document right now, and that's okay. But you need to at least let them know where they can find the document, who are the people they need to get in contact with, and really what their next steps are. And that sheet that I went through earlier, if you could create something like that for yourself, and like I said, I'm happy to share that with anyone, just to have something like that. And you don't need to provide it right now to your point person. Keep it in a sealed envelope in a safe place, but tell them where it is so they know if something happens, they have access and they can truly help you. Because if you don't give people the information they need to help you, it's not going to go well. It's going to be an uphill battle, and there's going to be a lot of problems. So I know for us in our office, we keep original wills in our fireproof will safe. And I do have some clients who say, hey, I'm just not comfortable giving it to my family member yet, or my, personal representative. So they give me a sealed envelope with that paperwork I had shown you earlier. They fill all it out, put it in a sealed envelope, and we keep it there for the personal representative. Now, of course, passwords change and things change, so it's not something that you can fill out once and hand to me and never look at again. That's something, again, that you have to update and share with us and your point person as you update things. So we're going to open it up to questions now. Any questions at all?
I don't know if you can hear me.
Yeah, I can hear you, Chris. Go ahead.
I have some comments and some questions, and maybe some other people might be interested. One thing that's on my mind, getting old is not simple.
Yeah.
And number two, I just like to mention, I like to at least do a yearly review at this point, just to make sure, we're all on the same page. I learn things, which is a good thing, I guess, right?
Yeah, that's great. That's it's better to do more than less. I gave the 3 to 5 year, but certainly if you want to review, yearly, that's great too.
Now, one thing I learned with my dad, before he passed away with his attorney recommended that before my dad passed away, we had power of attorney that we would take everything out of the safety deposit box before he passed away, because of this so-called lockdown business. And I understood once somebody passes away, the bank locks that safety deposit box for a period of time, which can be a problem, right?
Correct. And I went over that in the beginning, that you just want to be so careful and don't keep your original will in the safe deposit box. And truly, unless you have, jewelry that's of value, or blocks of gold, or, original stock certificates, something that really needs to be kept in that. I mean, if you're just keeping old wills and old deeds, you really don't need to have a safe deposit box, because those are things that an old will you shouldn't hold on to anyway, and deeds you can pull at the courthouse, so you don't need to worry about those.
Here's the thing. We found out some things. My dad was very secretive. We found out some things that were in that safety deposit box that we were glad to know before he passed away. So it was a plus to go into that. We actually closed it out before he passed away.
Yeah. And
I just thought that was a good point to bring up. And
yeah, absolutely. Thank you.
I'm sure you agree. You agreed with that thought.
Yes.
I have some. As you were talking, I was writing some notes. This gift business, and I wrote a note here. How do they know how much money I'm giving away? I mean, as far as I'm concerned, it's none of their business.
Yeah, so like I mentioned earlier, if you are going to apply for medical assistance and you're in the nursing home, they do ask for, and you are required to provide at least 5 years of income tax returns. And in some cases, they ask for 5 years of bank statements.
I know what you're saying.
But they will at the very least ask for the most recent 2 years bank statements, and then random months for the 3 years after that. Looks like Kathy has a question. I
know what you're saying, and I don't want to do anything illegal, but why should I have to show where my money's going? Do people ever mention that?
Yeah, I think if you want money from the government, they want to know where you've been putting yours. It's kind of a
Yeah,
quid pro quo kind of thing.
I think you know what I'm saying. Whatever.
Okay.
You know, some people, well, anyway, I
All
know
right. I
that.
think Kathy, you had a question, so I'm going to try to unmute you here. All right, we're going to move on, Chris here. Kathy, go ahead. Do you have a question?
Okay, that was a good point. Only one person should be appointed as a power of attorney and then maybe have a backup. Because I have two daughters. So,
Yes.
and my one daughter's the primary. So,
Okay, great.
eh,
Okay.
I think
All right. I think
one other thing. When should medical people be given any copies of these documents, healthcare documents?
so. You'd want to give a copy of the healthcare power of attorney and living will to your medical providers right after you create it, so that they can have it on file.
Yeah, I didn't know if that's with my doctor. I know the hospitals like to see those. It's like,
Yeah. Any medical provider that you interact with should have a copy of it.
other than the fact that my daughter would have a copy of those.
Yes,
But
you want to give it to the medical provider as well.
yeah, see, I have never done that. So,
Okay,
oh
great.
well.
Okay, so go ahead, Kath. I think we're going to move on, Chris, here. Thank you so much for your comments. Kathy, did you have a question?
Yes, I did. Just quickly, would it be possible for you to, if I emailed the request to ask for that form that you showed us, instead of mailing it to us, would
Sure.
that be possible?
Yes, that would be
If
fine.
we just went on your website and asked for the form?
Yes. Is there I'll have Nora answer that. Is there a spot on the site if she would email Nora, or should we just give her one of our email addresses?
Yes, you can either put if you're comfortable typing it into the chat, you can send it just to me or Jessica, or certainly my email address is nora@waltersgalloway.com. So it's NORA, and I'll put it in the chat for you all too.
That would be fine.
At Walters Galloway, and that would be great if anyone that's interested in that document, or certainly a link when we get it posted from this meeting, I'll be happy to share that with you as well.
I would appreciate it. Thank you so much.
Well, you're welcome, Kathy. I'll put my email address in there right now for you.
Thank you.
Thank you. All right. Any other questions or concerns? All right. Well, we really appreciate you all taking time out of your lunchtime here today, and we hope you all stay safe and healthy. And if you have any follow-up questions, you can always email Nora, or I can put my email in the chat here for you as well.
Jessica, it's Maureen. I just wanted to say thank you. I was having some connectivity issues, so toward the end I was a little in and out there, but I did learn a lot today. I thought this was a comprehensive overview, and you gave us a lot of great updates for what is current in 2020, so I really appreciate it.
Thank you. Thanks, Maureen, for co-hosting with us. And if anyone has any questions, like I said, you can reach out, or if you have ideas for future seminars, we'd be happy to hear them.
Thanks so much.
Thank you.
Everyone have a great day.
Bye.
Thank you.
Bye-bye.